In 1965, as part of President Lyndon B. Johnson's War on Poverty, Congress passed the Elementary and Secondary Education Act. The act guaranteed equal access to education for all school-age children by providing federal grants of taxpayer money to schools. Under the act, religious schools could also receive these grants. Florence Flast and other taxpayers were upset that the government was using federal funds to support religious schools. The taxpayers brought suit in the United States District Court for the Southern District of New York to stop Wilbur Cohen, the Secretary of Health, Education, and Welfare, from spending those funds. The taxpayers argued that the act violated the Establishment and Free Exercise Clauses of the First Amendment. The Establishment Clause prohibits the federal government from supporting the establishment of any religion. The Free Exercise Clause prohibits the federal government from hindering the exercise of religion. Because the act forced taxpayers to pay taxes in support of religion, Flast argued that the act both supported the establishment of religion and also hindered the free exercise of religion. But the federal officials claimed that the taxpayers lacked standing to challenge the act. A party has standing when the party has a personal stake in the outcome of the case. To demonstrate standing, the taxpayers needed to show that they suffered a concrete injury, that the injury was caused by the defendant, and that a favorable decision would likely remedy the injury. The federal officials moved to dismiss the case. The district court examined the United States Supreme Court's decision in Frothingham v. Mellon. In Frothingham, a taxpayer challenged a federal funding statute as unconstitutional. The Supreme Court found that the taxpayer didn't have a direct injury because her interest in federal tax revenues was small and indeterminable. Therefore, the Supreme Court held that the taxpayer in Frothingham didn't have standing to challenge the federal statute. Based on Frothingham, the district court held that Flast and the other taxpayers lacked standing. The taxpayers appealed directly to the Supreme Court. The issue was whether a federal taxpayer can have standing based solely on his or her status as a taxpayer. Writing for the majority, Chief Justice Warren held that the taxpayers had standing to challenge the act. Warren examined the court's decision in Frothingham. Warren concluded that Frothingham wasn't an absolute bar to taxpayer standing. A taxpayer has standing when the taxpayer has a personal stake in the outcome of the case. Warren determined that a taxpayer has a personal stake when Congress abuses its power under the Taxing and Spending Clause, which grants Congress the power to levy taxes to pay national debts and to provide for the general welfare of the nation. Warren set forth a two-part test to determine whether a federal taxpayer has a personal stake in challenging a law. First, the law must result from Congress's taxing and spending power. Second, the law must exceed constitutional limitations on this power. The court held that the taxpayer satisfied both requirements of the two-part test. First, the act was an exercise of Congress's taxing and spending power. Second, the act exceeded constitutional limitations under the Establishment and Free Exercise Clauses by using taxpayer money to support religion. Therefore, the Supreme Court reversed the lower court's decision and held that the taxpayers had standing to challenge the act. Justice Douglas concurred but didn't agree with the majority's two-part test. Douglas believed that Frothingham needed to be entirely overturned so that taxpayers could more easily challenge religious freedom violations. Justice Stewart concurred on the grounds that the Establishment Clause prohibits taxation in support of religion. Stewart concluded that every taxpayer has standing when the law is alleged to violate the Establishment Clause. Justice Fortas also concurred, but wished to narrow the majority's holding. Fortas argued that a taxpayer should only be able to challenge Congress's taxing and spending power when it is alleged to violate the Establishment Clause. Justice Harlan dissented, arguing that taxpayers shouldn't be able to challenge Congress's taxing and spending power. Harlan rejected the majority's two-part test because it didn't actually establish a taxpayer's personal interest in a case. So why is Flast v. Cohen important? Prior to Flast, federal taxpayers didn't have standing to challenge laws. Flast created an avenue for taxpayers to challenge Congress's use of its taxing and spending power. Many taxpayers brought lawsuits in the years following this decision.